All right. These are the days of technology and video, and I constantly demonstrate to myself how unfamiliar I am with all of these things, including the lighting aspects of it and everything else. So I commend all of you for being far better at those things than I am. I am going to go on, and I'm going to talk about the purchase agreement that is about to come out in a month or so. And we'll try as much as possible to make reference to the prior purchase agreement. And I encourage anybody to ask any questions. I've only had myself a little bit of time to look at this agreement and get acquainted with it. And I encourage all of you to spend some time over the next couple of months to look at the agreement. The agreement got longer. It's now 16 pages in length. And, I understand a lot of the changes that have been made, and some of them make a lot of sense to me. Some of them I think are a little bit, they might be prone to some, to generating disputes rather than minimizing disputes. But on the whole, I really trust and rely on CAR, the California Association of Realtors. And I'm going to say this likely throughout this entire presentation, and I'm going to encourage all of you to take it to heart. Please let the contract do its job. Don't try to reinvent it. Don't try to significantly change it. And don't think that you or your buyer or your seller or anybody else has more knowledge and experience with how to structure these deals than CAR does, because these agreements are they're crafted and cultivated over decades. And what we're getting now is an updated version. I think it's been 3 years since we had our last version, but this is a constant ongoing process. And these forms are, as I like to put them, highly evolved. They reflect experiences that the industry has had, feedback that the CAR attorneys have gotten. And, I've been on conference calls with some of these CAR attorneys. There are, several of them, and this is just their sole job is to think about these agreements and revise these agreements and make changes to these agreements. And so please don't try to significantly alter these contracts. Whenever possible, defer to the contract and resist as much as possible significant changes to the contract. Let the contract do its job. Now I'm going to go back to share screen here. And the first thing I wanted to call your attention to, and I hope that everybody can see this. Let me move this off to the side. So what we're looking at here is the CAR form RPA dated December 2021, and that's next month. So it's my understanding that this agreement is not yet available on your zip forms or your system. Maybe it is, maybe it isn't, but it should be coming out in the next month or so, and it should be ready for use. One of the questions that people ask is, well, what happens if I use an old form? Generally speaking, you should be using the new form, and I think that the system will automatically update so that that's the only form you can use. Technically, however, the buyer and the seller are free to use any form of purchase agreement that they want. And if for any reason a buyer and a seller insist on using a prior version of the RPA or any other purchase agreement, they do have that right. But our recommendation and our practice and standard of care should be, we want to use the CAR purchase agreement, and we want to use the most recent version of it, which now is going to be this one. Now I'm gonna, I don't know how familiar some of you are with the Adobe program and things like bookmarks and whatnot, but sometimes it's helpful for me to have a document like this CAR residential purchase agreement, and pull it up and just have it as my own template or version. And what I do is I create bookmarks in the document wherever a term is that I want to look at. And as a way of reviewing these documents and keeping track of them, if some of you are familiar with Adobe PDF, I would recommend that you have your own little private version of this, and you go through the agreement and you create little bookmarks for provisions and things. It allows you to skip around. I can go down here to the all cash provision of the agreement. I can skip back up to the first page, etc. And the act of making these bookmarks and giving these sections names and reading them is, for me anyway, part of the act of becoming more familiar with the agreement, and it makes it quicker to go back and look up things. Now, I'm going to be referring from time to time to the old agreement, the so-called old agreement, and I hope everybody can see that. This one was dated in December of 2018, so it's been 3 years. And I may call our attention to some changes between this agreement and the other agreement, but mostly we're going to be talking about the new one. Now, I'm going to kind of go through in order here and talk about some of these terms. And again, I encourage people to ask questions. You know, one of the things that CAR has tried to do in recent years is they put this provision up here for date prepared. You know, one of the problems with this document is it's got this sample template watermark in the background, so it's not always allowing me to highlight things, but I'm moving my cursor around here. The date prepared is an important piece of information, and it's not so much a material term. It's not really a term of the contract, but it's a reference point. So the date prepared refers to the date usually the buyer's agent prepared this as an initial offer. Obviously, the date prepared may be different than the actual acceptance date, but we have this reference to date prepared so that we can constantly refer back to this RPA, and it has a reference date. Some of the documents that arise in a transaction will be like, for instance, a demand to close escrow, or a cancellation, or a notice to perform, or anything, and it will ask you to identify the agreement. And we typically want to say things like the RPA, the residential purchase agreement, dated, and this is why we use a preparation date. It's solely for identification purposes. And because the date of acceptance can sometimes be several days after the date it was prepared, it's important to keep in mind this date of preparation so that you can constantly refer to it whenever you're trying to address this particular RPA. And I have seen people sort of mess this up, and they'll start referring to the RPA by all kinds of different dates. And, you know, as long as we know what we're talking about, that's really not a huge deal. It doesn't invalidate anything, but it makes it clearer if you can always refer back to this date of preparation as the identification label date for the purchase agreement. It's not the date of acceptance. Obviously, the next line, this is an offer from, and it gives you space to fill in the buyer. Now, it's my understanding that this form is going to allow what they call double stacking. Now, I'm not precisely sure what double stacking means, but I think it means you'll be able to fit at least up to 4 individual buyers in here. You'll be able to stack them. That's what I think it means. But it's supposed to accommodate identifying more buyers. And you want to identify all the buyers of the property. And if it's going to be an entity such as ABC Limited Liability Company, or John Smith, trustee of the Smith Family Trust, you want to try to identify those buyers' names as much as you can. The buyer's names, for instance, like an entity or an LLC, it doesn't have to be precise in this section. It just has to be significant enough or clear enough to identify who the buyer is. There are later sections of the agreement that require you to more precisely identify the buyer. But it's my understanding you'll be able to put more buyers' names in here, and we want to identify all the buyers who are going to be submitting this offer. Sometimes I get the question, you know, can we write and or assignee in there? And that happens a lot. And this is another example of something that is added to these agreements, but is not necessary because the agreement already contemplates a potential assignment. So you can add in phrases like and or assignee, but it's not necessary because the agreement itself has an assignment provision in it. Now, it may be beneficial to put in the phrase and or assignee because you may, for instance, this happens frequently in limited liability purchasers, limited liability corporation purchasers. They want to make it clear that they're planning on taking title to this in some different name other than their name, or they could be trying to find an assignment buyer, and they just want to telegraph that up front. There's nothing wrong with that. You can do it if you want, but it's not necessary. There are assignment provisions in here that provide for the conditions under which an assignment can be made, and we'll talk about those in a little bit. One of my favorite provisions, and I always talk about it, is this paragraph 1D here, and this is a situation where it's not really letting me highlight this. You see what happens, the whole thing lights up. But in any event, it's important to point out that the buyer and the seller are referred to as the parties. The parties to this agreement are the buyer and the seller. The brokers and agents, that's you. You're not parties to this agreement, and it bears constant repeating and emphasis, because when disputes arise, when issues arise, it's worth it to take a step back and remind yourself, hey, I am not the buyer or the seller, and there is a buyer or seller, and our job is to sort of think about what's in their best interests and try to act accordingly. And, to consult with them. What do you think we ought to do? It's your purchase agreement. It's your sale agreement. How do you want to proceed? And I know that many times they'll come back and they'll say, I don't know, whatever you say. And that's fine. But just remember, you're acting on behalf of a buyer or seller, and you are not the buyer or seller. Oftentimes, agents will call me up and they'll say, oh, they want an extension. And they say to me, why should I give them an extension? And I always have to kind of remind them, what do you mean you? You're not the one giving them the extension. Your buyer or seller is giving them the extension, if they do at all. And it's a thinking exercise that reminds you that you're not the party, the buyer or seller is. And even if you still decide that it's your decision, I just would prefer it if at least you take a step back and remind yourself for one brief moment that it's the buyer and the seller who are buying or selling, not us. We are not the buyer or seller. Now, here is an interesting provision. So this is the big major change that Carr has done. They have added this grid. And what they say here, this grid is basically referred to now as paragraph 3. And it goes on for basically the next 3 pages. And some people might be tempted to look at this and say, well, that's just a summary of the general terms, but it's not. These provisions are going to be actual terms of the agreement. And they're put in this way so that they're clear for the buyer and the seller to identify and to see. But the terms that we write in here are the contract terms. It isn't just done for summary purposes. It's done because these are the contract terms. So think carefully about what you're writing in here. If you're, say, a buyer submitting an offer, think carefully about it, because the terms you're writing in are intended to be the terms of the contract. Okay, and the agreement says something here. They added this phrase here. It says the items in this paragraph, paragraph 3, and it goes on for 3 pages, are contractual terms of this agreement. So that's just what I said. Reference paragraphs provide further explanation. So paragraph 3 is designed in these alpha sections. There's section 3A, 3B, 3C, D1, D2, E3, and we'll go through some of these and talk about them. But then the next thing refers to paragraphs within this RPA where you can find out more information. If you want to know more about the purchase price, go to paragraph 5. If you want to know about the expiration of the offer, go to paragraph 32A, 5A1, 5A2, etc. So I like this. I like the fact that it identifies the paragraphs that the reader is supposed to go to look for more information. And that can lead to a lot of bouncing back and forth. But remember, these are the contractual terms. And it says something else. It says this form is 16 pages. The parties are advised to read all 16 pages. I want you guys to remember all of that. Now, I recommend that all of you take some time over the next couple months to try to familiarize yourself with this agreement and try as best you can to read it. Maybe you'll take little notes and make bookmarks or things like this. Maybe you'll put Post-its in there. Whatever you want to do, however you want to do it. But it's important that you spend some time understanding the general contours of this agreement. But, and I frequently hear this, it is not our job to read these agreements for the buyers and sellers and spoon feed the buyers and sellers as to what these agreements say. You can try to do that if you want, if you're trying to accommodate them, but just remember to remind them that it's their obligation to read all of this and that they're advised to read all of this. Now, that doesn't mean you have to say things like, I'm not going to tell you anything that the agreement says because it's your job. But don't forget, at the end of the day, it goes back to the fact that the buyer and the seller are the one who are entering into this agreement, and there's no replacement for them reading it and understanding it. So things like, well, I'm happy to try to answer any questions that you have, but just remember, it's your agreement and there's a lot of stuff in there, and you should try to read it and understand it as best you can. And if you have questions, let me know. I defer to each one of you as to how you're going to handle that. The first sort of matrix table item is the purchase price. And I find it interesting that Carr decided to put as the first two terms, the purchase price and the close of escrow. And I think that Carr made an effort to put all of these items on the first page here, and they come down to this net purchase price total. I think this was conscious. This table goes on for 3 more pages. But Carr did its best to ensure that all these provisions were on the first page and that the first page ends with this purchase price total. So obviously, when you're the buyer and you're filling this out, you're going to put in a purchase price. That is the purchase price of the offer. Now, you'll note that there's a box here to check if this is going to be an all-cash offer. This is a little bit more streamlined than it was before. There used to be a box that said all cash offer, no loan is needed. And then there was another box that said no loan contingency, etc. And they sort of were duplicative of each other. So what Carr has done is they just have this all cash box here. They don't have an explanation. And the explanation for what all cash means is now found in paragraph 5. But you want to write in the purchase price. And I encourage you to write in a purchase price. I see people say things like, $10,000 above best offer. Well, you can do that. I don't particularly like that because I think this needs to be a concrete specified offer. If the seller wants to counter, they can counter, but the theory is that you're writing this offer so that it can immediately be accepted and turned into a final contract. I personally don't like to see a vague phrase in there that says something like, well, we'll agree on the price later depending upon what your offers are. So I recommend putting in a precise dollar amount there. But people are free to deviate from that if they'd like. I would recommend against it, but some people are comfortable doing that. Now, I like the fact that the very next term is close of escrow. And to me, close of escrow is an extremely important detail in a purchase agreement, and it is often overlooked. Everybody wants to know what the purchase price is. Oh my God, $2 million. And they checked a box that said all cash. And many people then say, who cares what the rest of this says? I'm seeing $2 million all cash. But the close of escrow is a very significant detail that is frequently overlooked. And I believe that we need to pay more attention to the close of escrow date. And I'm grateful to see that Carr moved it up into item B here, the second most important item, or at least that's what I'm treating it as. Because if you get, say, a $2 million all cash offer and they put in something like 60 or 90 days to close escrow, that should raise some sort of question or red flag in your mind. if this is all cash, why is it taking so long to close escrow? And I'm not saying that a seller should reject an offer just because it has a long escrow period, but I do think that people should try to make some sense to understand, why is the escrow going to take so long to close? And if the explanation makes sense, well, then by all means, go ahead and proceed. But to me, when I see something like all cash, 90 days to close escrow, I immediately think they're going to try to monkey with the sale price. They're going to have 90 days to try to tie you up in a contract as a seller, and then try to ask for repairs and discounts and all of that. So I think it's very important to focus on the close of escrow date. 30 days is obviously great. 45 days, not so bad. When I start seeing things like 60, 70, 90 days, I don't say that's terrible and they should be rejected, but I want to know why. Why is it taking so long? And if the explanation makes sense, the explanation makes sense. Expiration of offer. Here's a default provision. So this is a situation where, and apologize, there's some background noise. So if you have your sound on, you might want to mute it so that we don't all hear that. Okay, so expiration offer 3 calendar days after the buyer signs the purchase agreement. That's a default provision. So there's lots of these default provisions in here. And unless you fill in a box or put in a time or date, it'll default to 3 calendar days. Now, my suggestion is, if there's a default provision in there, just go with the default provision. Don't try to alter it, but you have that discretion, or buyer has that discretion to alter that term. People sometimes ask me, what's calendar days? And I have to tell them, calendar days is calendar days. It's exactly what it means. It's a regular day. Business days are essentially non-holidays, Monday through Friday. Okay, initial deposit. Now, this is kind of an interesting thing here, because it has 2 spaces. It has a space for a dollar amount, and it has a space for a percentage amount. And, my preference is that I personally don't think you should put in the dollar amount, or at least you should be cognizant of what you're saying. I think a better practice is to specify, say, 3% of the purchase price, because the offer amount that you make could change if the seller, say you submit an offer for $1 million, that would indicate a 3% or $30,000 deposit, but the seller comes back and they say, well, we want 1.1, and nobody addresses the deposit amount, and you guys agree to 1.1, and now you have this sort of conflicting term. You have 3% here and 30,000 here, and it leads to a little bit of a potential ambiguity. Not a big deal, but I personally don't like the idea of having that ambiguity. I would be inclined to just say 3%, but it's up to everybody to decide what they want to do. And, that's just a stylistic preference. People can think about that all they want. I'm going to, increase deposits. Generally speaking, this is rare. I'm not going to spend too much time talking about it, but it's a situation where, for whatever reason, the buyer and seller agree they're going to put more money into the deposit before the close of escrow. And then there's forms and things that you're supposed to fill out upon those conditions. And removal of contingencies by putting them in. And in my opinion, when people enter into the agreement, they're not contemplating increased deposits, nor should they. So I wouldn't get too bogged down for that. I would just leave that blank. And then, of course, your loan amount. And again, it's the same issue with the initial deposit. I would recommend putting in the percentage. Now, you can put in whatever amount you want as far as the dollar amount, but I personally prefer the percentage, because if the price changes from the offer, the percentage was specified. Say 80% would be sort of a common number. So 80% of the purchase price. Now, obviously, you've got to understand, can your buyer put in 80% if the purchase price goes to 1.1 or 1.2 or whatever it might be? But I'm assuming that the buyer is able to do that. Now, CAR talks about how the buyer may want to specify an interest rate not to exceed a certain percentage, because the default is some sort of fixed rate, And so that's an ambiguous rate. And a seller could say, well, I don't care if you got approved for a loan at 8%. You didn't specify that you wanted to cap your interest rate. So I do think it's important for buyers to consider about whether they want to put a cap on an interest rate there, because if your lender can't meet or beat that interest rate, then you have a good faith exercise of your loan contingency. Let's say, just for ease, you put in 5% there and the lender comes back at 6%. You could say, well, we're not going to remove our loan contingency. We're going to cancel. We didn't get a loan at 6% and 5%. And this provision gives your buyer more protection with respect to exercising their loan contingency. Otherwise, a seller could say, well, you didn't specify a percentage, so we're not giving back your deposit. I'm sorry that the best loan you got was 7%, but that's on you. If there's going to be a second loan, you would specify that here. But generally speaking, I'm looking at situations where you're putting 80% down, you're putting 3% in on the deposit, and then you're paying the remainder of the purchase price, down as the balance of the down payment due, and then the purchase price total down there. So this is a good way, I think, for CAR to, in one page, kind of summarize and encapsulate the entire offer, and if accepted, the entire purchase agreement. It's upfront, but remember, these aren't just summaries. These are actual contract terms. And so the numbers and things that we put in here, they are the terms of the contract. If there's some sort of ambiguity, for instance, you write down $30,000 and 3%, then that can lead to some level of ambiguity here, but that's not really going to kill your contract. It's just something to be mindful of and proceed accordingly. The last thing that they have here is the occupancy type, and CAR again defaults to the primary. It's primary. The buyer is going to be the primary occupant. That's the default. And if that's not going to be the case, then the buyer is expected to check, either secondary or investment, depending upon what the situation is. All right. So that's a brief overview of the first page. And let's go over a couple of things here. I said brokers are not parties. Oh yeah, 2C. I get this question a lot. 2C says, if there's going to be more than one brokerage representing the seller or the buyer, see additional broker acknowledgement, CAR form ABA. So, I got this question the other day. What form do I use if two brokers, meaning that you and an agent are both going to represent the same person, but you and the agent are with different brokers? And contrary to popular belief, being with Keller Williams does not mean you're with the same broker. So for example, if Keller Williams Larchmont agent was going to represent the buyer, and just by sake of example, Keller Williams Beverly Hills agent was going to also co-represent the buyer, then you would have two different brokers, because each Keller Williams office is a separate broker. And you would check that box, and then you would provide an additional broker acknowledgement, a CAR form ABA. Not a big deal, just something to be aware of. Okay, I'm going to go to page 2, and I suppose if there are any questions, we can field those now just on page 1. A lot of any questions you might have could be answered once we keep going, but if anybody has any questions, feel free to ask them. Otherwise, I'm going to skip on down to page 2. Okay. Well, let's go back up here to terms. One of the questions that I get a lot is whenever there's an all-cash buyer, the buyer is supposed to provide some verification that they're going to be able to purchase all cash. And the paragraph that covers this is paragraph 5B. So if we skip down a little bit and we go to paragraph 5B, it says, if an all-cash offer is specified in 3A above, that's that little box, no loan is needed to purchase this agreement. This agreement is not contingent on a buyer obtaining a loan. Buyer shall, within the time specified in 3H1, deliver written verification of funds sufficient for the purchase price and closing costs. So that's what 3H is referring to, verification of all cash sufficiency. And the default is that the verification is going to be attached or accompanying the offer. If you want to submit, if you're the buyer and you want to make an all cash offer and you want to submit the verification 3 days later, then you would check that box. Now, so as a seller, if you see an all cash offer, remember I was telling you earlier to just be a little bit, be prepared to do a little bit of due diligence anytime you see an all cash offer. How quickly are we going to close? And if we're not going to close immediately, what's taking so long if you're all cash? And number three, well, where's the verification of your all cash liquidity? And the offer says it's supposed to be attached unless the 3 days are checked. So, I might call the buyer's agent and say, listen, we like your offer, it's good, but before I discuss it with my seller, can you please provide the verification of your cash solvency to do this? And I get all kinds of questions of, is this sufficient? Is it not sufficient? There's no real ironclad way to say, oh, that's it. They just proved they have the cash. Each situation is different. And oftentimes you'll get a bank statement that could be 1 or 2 months old, or, an individual, an LLC buyer will submit a bank account statement in his or her own personal name. And, it's unclear, these are personal monies, are they the LLC monies? But generally speaking, if someone submits some sort of bank statement or document which shows that they've got cash lying around to close this deal, that's usually, for my purposes, sufficient verification of funds. And if you can discuss it with the seller and say, this is what they provided, it's a personal account, but this guy seems to be acting on behalf of the LLC. And as far as I'm concerned, they've shown that the money's in the account. So I feel comfortable proceeding, but it's up to you, seller. Let me know if you have any concerns. Keep in mind, however, that just because they say that they're going to be all cash does not mean they're not going to try to get a loan. And it is frequently the case, or at least it's often the case, that an all cash buyer, one of the first things they'll do is they'll try to get a loan, because that's how buyers with all cash keep their cash. They have that cash sitting around. They don't like to part with it. So yeah, they check the box that said all cash. Yeah, they do not have a loan contingency because it says not contingent on getting a loan. But hey, one of the reasons I got to have so much cash is I always borrow. I don't spend my cash. So I am going to try to get a loan. Don't be shocked if that's what a buyer does. And that's one of the reasons why we would, check to see the length of escrow and the verification of funds, but don't oversell an all cash buyer on your seller, because they may very well try to get a loan. And my attitude is, I don't care where they get the money from. I care about whether or not it's going to close on the scheduled close of escrow date for the price that they agreed to pay. And frankly, I don't care whether they have $1 in cash or $1 borrowed. I just care about whether or not it's going to close on time for that price. Everybody's different. That's my personal opinion. I offer it to you for whatever it's worth. Okay, back up to the grid.
Quick question, Peter.
Yes, sir.
So in that case, let's say you send a notice to perform, they still didn't get their loan, they're past those days. Can you just send a cancellation and then keep their deposit? Ideally, but.
Well, you've asked a very good question, but you sort of lumped in several concepts there. You said if you want to send a notice to perform, I assume that you're sending the notice to perform on behalf of the seller. And then my question to you is, what exactly are you asking them to perform within the 2 days notice to perform? Because you're not asking them to remove a loan contingency because they don't have a loan contingency. Presumably they're an all cash buyer. All cash means they do not have a loan contingency. So you're not asking them to remove the loan contingency because they don't have a loan contingency. So if you want to enforce, well, first of all, I don't think you should be over aggressive about trying to prevent them from getting a loan. It doesn't mean they're not going to close. And technically speaking, there's nothing that says they can't get a loan. They've just agreed up front that that's not a contingency. And that's why I like to keep my eye on the end date. What's the game clock say? 30 days to close. I don't care how we get there as long as we get there. So if you want to, yank their chain, so to speak, on something else, you can. But technically speaking, for instance, what we're going to talk about here is what Carr did in this agreement is something that I actually think is really, really great. I'm going to tell you all right now, and we're going to talk about it in a little bit. Carr basically changed all the contingencies to 17 days, all of them: appraisal, inspection, loan, and other contingencies that are less, noteworthy. But we're going to talk about that. So the contingency time period for those 3 big contingencies and others is now by default 17 days. You can change it if you want. You can check boxes and shorten or lengthen contingencies if you want. You guys know my philosophy on that. Don't mess with that. But, a typical purchase agreement for a standard residential primary occupant buyer should be around 30 days. And all the big contingencies, all the contingencies are due in 17 days. And so, for example, if you've got an all cash buyer who's mucking around trying to get a loan, I wouldn't be too surprised or upset about that. And I wouldn't be, I'd be prepared to let your seller know that that might happen. If you want to play poker and act like, this is an outrage, you can, but don't really let that rock your boat. But you've got other contingencies that you can exercise. Your 17-day clock is coming up. So you could just send on day 15 a notice to perform to remove all contingencies. And here's the rule on that. If the seller sends a notice to perform demanding that the buyer remove all contingencies upon their expiration, which I'm going to say is 17 days, if the buyer removes those contingencies, now their buyer's deposit is at risk. I don't ever like to say that the seller will get to keep the deposit or the buyer will definitely get the deposit back, because once a deposit's in escrow, it's not coming out of escrow until both parties sign an agreement to release it. So I don't like to guarantee that the money's magically coming back. I like to say things like, well, the contract says you're entitled to the deposit, or the contract says you're supposed to get it back. Okay, so if you send the notice to perform to remove everything timely on day 17, if they do not remove all the contingencies, then the seller, after the expiration of the 2 days, does have the right to cancel. But the contract specifically says that if the seller cancels for failure to remove contingencies after sending a notice to perform, then the seller shall, that's the word, shall authorize return of the deposit to the buyer. So, so the short answer to your question is, if you send a notice to perform to remove whatever contingencies, if the buyer doesn't, and if the seller then cancels because of that, the contract says the seller's supposed to give the deposit back to the buyer. And I'll just really quickly show you where that is. It's in paragraph 14, great paragraph. Seller right to cancel. If by the time specified, buyer does not remove a contingency, seller, after first delivering to buyer a notice to perform, may cancel this agreement. In such event, seller shall authorize the return of the buyer's deposit. So that's where it says that. So the message to sellers is, and to buyers is that the deposit is not really at risk, or it's exposed to as much risk as it can be exposed to when all contingencies are removed. And that's what exposes the deposit to the risk of, under the contract, of not being refunded. And until that happens, the buyer's, in my opinion, entitled to get their deposit back. And the other thing to think about here is I see agents, buyers and sellers agents, sellers agents in particular, really getting into fights over deposits. And, you know, knock yourself out. I welcome you to do it. If you want to try to get that deposit for your seller, go ahead. But I would remind you, at the end of the day, that's not really helping you get paid. Because when the buyer and the seller get into a dispute over the deposit stays in escrow. It doesn't come out until both the buyer and seller sign something, say, letting it go. And meanwhile, if you're the listing agent, you still want to get paid. Now, there's a provision in your listing agreement that says if the buyer collects that deposit, the listing broker is entitled to half of it, but I have never, ever seen that enforced. And my experience is that most listing agents and brokers don't want to treat their sellers that way. And I completely respect that, but you're not getting paid over a deposit. Nobody is. So agents for buyers and sellers get paid when they make a sale. So anything that helps you make a sale and earn a commission is what you should be striving to do, in my opinion. So if you have a deposit dispute, means that you don't have a mutual cancellation. Many times the buyer will submit a cancellation that says, give me my deposit back. The seller will submit a cancellation that says, I get to keep the deposit. And both those cancellations will sit in escrow. They're non-mutual. And so you don't have a mutual cancellation. So in theory, when you go to sell to another buyer, which you can do, you have to disclose to that other buyer that you don't have a mutual cancellation. And you're supposed to have what's called a backup offer addendum, a BUA, I believe. And that BUA says that the buyer has the right to cancel if they don't get the mutually signed cancellation. Not a big deal, but sometimes that spooks buyers. And so you have all these sort of lingering issues over a deposit that's not even going to get you paid. And it may actually slow down your ability to sell to someone else. You shouldn't be afraid of it, but this is one reason why, at the end of the day, there's not much incentive for us to get into a fight over a deposit unless we're just trying to demonstrate to our buyer and seller that we're really good and we're loyal to them and they should stick with us, which is a perfectly good reason, but it's not getting you paid per se. All right. Now, great question. I really appreciate that. And I welcome any and all questions. Okay. Blah, 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 blah. Let's see, where are we? Occupancy. We talked about verification of all cash. Now, here's the contingency. Oh, here's an interesting thing I wanted to point out. Now, I told you before that this agreement is now revised in December of 2021. The last one was December of 2018. I think that I've been doing these contracts now for, over 10 years, at least, probably longer than that. And I've seen probably at least 3 or 4 revisions to the RPA during that time, as well as all the other forms. And I've done historical searches for older RPAs, and they go back decades. And this is what I'm trying to impress upon all of you, that these contracts are highly evolved. They reflect decades of experience by people whose job it is to draft these things. So we don't want to unduly interfere with these contracts if we can avoid it. Now, here's something that Carr did. This is paragraph 3. This is the matrix table. This is the second page. So it starts at paragraph 3, 3A, B, C, etc. And on the second page, you get to paragraph 3I. And Carr said, intentionally left blank. And I looked it up and I said, I wonder why they left that blank. And here's Carr's explanation. They said that I looks a lot like 1. And since this is paragraph 3I, they didn't want to create unnecessary confusion by people trying to figure out whether you're referring to paragraph 3I or paragraph 31. Now, as a guy who reads contracts and looks at them, I actually find that amazing. Most of you are probably thinking, well, that seems pretty silly, but I actually really commend Carr for having that kind of attention to these things. And, it's just another reminder that they're sort of really looking out for us. And these forms are well adapted to try and help us. They do the exact same thing in paragraph 3.0, which could be confused with paragraph 30. So, I appreciate that. That's a small drafting detail, but I really commend them for that level of detail. They're thinking about us and our buyers and sellers, and they're trying to avoid disputes whenever possible. Now, under this paragraph, you have the verification of final condition, and you have assignment requests. So the default here says that verification of final condition shall take place 5 days prior to close of escrow. And for more explanation on that, you can look at paragraph 16, which we'll talk about. And it also contains an interesting provision here, the assignment request. So it says here, the assignment request should be made 17 days after acceptance. Now, this is a new provision. I've never seen a time deadline for a buyer to make an assignment request before. It's not clear to me how enforceable that 17 days is, but I think it's interesting that they put it in here. And it's worth now taking a look at the assignment provision, which is down in paragraph 23.
Peter, can you bring the RPA up on your screen?
Yeah, isn't it up?
No.
Oh, I apologize. It says I'm screen sharing.
Is it?
Yeah, we see.
Okay,
No, it's not up.
I just stopped sharing, and now I'm going to share again. But
Thank you.
it told me I was sharing, so I apologize if someone joined late and I had to add them in. If anybody else comes in or doesn't see it on their screen, let me know, and I will do a stop share and then a restart share, and hopefully that will incorporate you. Okay, thank you very much for that. So let's take a look quickly at the assignment provision, because there are some details in there that are worth talking about, because assignment provisions come up a fair amount. And the assignment provision is down here, paragraph 23, and I put a couple of stars around there, which meant that I wanted to talk about it. Okay.
Peter, I'm
Yeah.
sorry to interrupt. I had your screen and then you just adjusted and I lost the screen.
All
I
right.
had to share screen when Rob didn't, and now I have a black screen.
Okay. I stopped, shared again. Are we there? Lena?
Yes, I got it. Thank you, Peter.
Okay. All right. So here's what the assignment provision says. The buyer shall have the right to assign the buyer's interest to the buyer's own trust or to any wholly owned entity of buyer that is in existence at the time of such assignment. That language was never there before. It basically says if a buyer has a trust, then if the buyer is the trustee of a trust, but he entered into the contract as an individual, the contract says the buyer has the right to assign it to himself as the trustee of his trust, or to basically have his trust purchase the property, or to any wholly owned entity of buyer that is in existence at the time of such an assignment. So it's telling us up front that these types of assignments, the parties are agreeing up front that this type of assignment is permissible and it's contemplated. Now, it says that that entity has to exist at the time of the assignment. So they have to form it before the assignment. They can't just have the assignment and then form it later, which, by the way, happens a fair amount. These guys are fast movers, flippers, wise guys, whatever you want to call them, and they'll sign it. They'll create an entity, they'll name it, but they haven't even formed it yet. And then they'll form it later or at the 11th hour. I've seen that happen. That's not what they're supposed to do. But it says up front that that type of assignment is permissible. It doesn't say what happens if the buyer tries to do that on day 19 or 20, but generally speaking, as a seller, my attitude is, I don't care who the buyer assigns this property to. I don't care what title the buyer takes. I just want the thing sold on time for the price paid. That's my view generally from a seller's point of view. But if any of you have questions or issues, then obviously give me a call and we'll talk about it. And then it goes into the otherwise section. And that basically covers any other kind of assignment. And it says that the buyer shall not assign any of this without first having obtained the separate written consent of the seller to a specific assignee. Such consent shall not be unreasonably withheld. Prior to any assignment, buyers shall disclose to seller the name of the assignee, the amount of any monetary consideration. Sometimes a contract buyer will flip or assign it to another assignee buyer, and there'll actually be some money exchanging hands pursuant to that. This says that the seller is entitled to know that. The buyer shall provide the assignee with all documents relating to the agreement, blah, 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 blah. Let's see. And there's a reference here to CAR form AOA, which is the, I think it's the assignment of agreement addendum. So that's the assignment of agreement addendum is the form that you use to effect the assignment. And that document will typically say the assignee buyer acknowledges that the assignee buyer has gotten all of the sale documents and they acknowledge receipt. And it also says that the assignment does not relieve the contract buyer from all the same obligations as the assignee buyer. So the way I look at assignment is when you have a buyer assigning his or her interest to another buyer, you really have two buyers because they're both saying, I'm a party to this contract and I agree to buy. So generally speaking, I don't see any harm in an assignment buyer. It usually means there's two buyers and not just one. And between the two of them, they'll have to figure out how title will be taken, et cetera. Those are the provisions regarding assignment. I think it's very interesting that CAR added this provision saying if a buyer is assigning it to his or her own trust or to any wholly owned entity. Wholly owned means that that buyer is the only owner of that entity. So like a one-person member LLC or something like that. What happens if the buyer is if the assignee, the contract buyer is the managing partner of a 2 or 3 member LLC? So it's not wholly owned. Well, to me, I don't think that's that big a deal, but technically that's something different. And I don't know if sellers are going to start saying, well, it's not wholly owned, so I'm going to deny, because it says the seller has to still be reasonable. And, you know, I think as agents, we don't want to get our parties too wrapped up in this agreement. I generally don't have any problem with assignments as long as the first buyer is still obligated, just like the second buyer. And you get this AOA form signed off that says the second buyer acknowledges receipt of everything. And I will tell you further that we can get that form signed off on the AOAA, and escrow will almost certainly require a similar form. And so generally speaking, I don't think there's a real problem with assignment, but I did want to call that to your attention. And it's another reason why you don't have to add the phrase and or assignee to the buyer. You can if you want to telegraph to the seller up front that you're contemplating assignment, but the agreement already provides for assignment provisions. Okay, now I'm skipping around. Let's go back up to the terms grid. Oh boy, lots of terms. Okay, now here are the contingencies. Here are the contingencies. Loan contingency, 17 days. Appraisal contingency, 17 days. The investigation of the property, 17 days. Informational access to the property. They added this. This is to my mind, this is sort of a new contingency. The buyer has the right to access the property for informational purposes only. And then it says it's not a contingency and it does not create additional cancellation rights for buyer. I'm not really sure why CAR added that. And I think that may cause some sort of confusion. The contract does provide that the buyer has to make the property available for investigations. I'm not quite sure what Carr is thinking there, but it is there. The buyer has the right to access the property for informational purposes, but not as a contingency. And maybe the theory is that, honestly, I just don't know. I'm not quite sure what Carr is thinking there, but I do
Peter?
trust. Yeah, go ahead.
What happens sometimes, you get a temperamental seller who, feels like you've looked under the hood enough.
Yeah.
Right. And you've taken off all your contingencies and, just give me some space from here till the close of escrow.
Well, I agree, and I understand that. The only thing is, it says 17 days for each of these. So if you're going to be removing your investigation contingency after 17 days, what's the purpose of having this in here and saying it's not a contingency? Because
it has no teeth.
Well, it doesn't seem to have any teeth. Look, I wouldn't get too bogged down on it. As I said, I trust Carr. I do. I know they had a good reason for putting this in here. And as I was looking at this, and as I was just thinking about it, and as Joey and I were just talking about it, I was thinking the exact same thing that Joey was. It still doesn't quite make a lot of sense for me, but you know what? My job is to delve into these details, and you guys need to keep a little bit bigger picture. I wouldn't worry too much about it. It's there. I want you to be aware of it. We'll have to navigate through those situations as they arise. My attitude is, if the buyer wants to go look at the property, let them go look at the property. If they've removed their investigation contingency, that would encompass this. Let them go back to the property and look around. They've already removed their contingency, but that's me. And every seller has the right to say, no, you've done enough. And sometimes sellers can be prickly. So it is what it is. I do think it's interesting that they have contingencies here for loan and appraisal. And if the buyer wants, the buyer can check the box that says no loan contingency, and they can say no appraisal contingency. They can do one or the other. Keep in mind, even though people think these two contingencies are connected, they are not connected. They are separate, standalone, independent contingencies. And someone says to me, well, if you don't have a loan contingency, why do you need an appraisal contingency? And my answer is, the appraised value of the property, in my opinion, is a material fact. Even if an all-cash buyer comes in and says, I'll give you $2 million for it, I don't even need a loan contingency, but they have appraisal contingency, and the appraiser looks at the property and says, well, you can buy it for $2 million if you want, but it's only worth 1.9. I think a buyer has the right to say, well, it didn't appraise, I'm sorry, see you later. Now, you often hear people say things like, the buyer has to make up the difference. And please don't do that. Please don't do that. It's an attempt to remove a contingency that already exists. If the buyer is going to go forward, the sale price has not changed. So if it underappraises at 1.9, a buyer could go back to a seller and say, hey, listen, I know I said 2 million, but it appraised at 1.9. Seller says, well, the sale price is 2, take it or leave it. So the buyer has to make up the difference if the seller refuses to change the price. So there's no need to try to ram that language in there. And it doesn't even have any real, it's not even clear what it means. It's an attempt to deprive them of an appraisal contingency that they already have. Unless the purchase price changes, the buyer has to make up the difference. How they do it is up to them. But they do have the right to cancel if it underappraises, which is rare, but it happens. So don't think that loan and appraisal are like Siamese twins and they go together. If one's gone, the other is. They're not. They're separate and they're standalone. And Carr says if a buyer wants, they can remove those things at the offer stage. They can take them out and say, listen, I'm a hot shot. I got a lot of money. I drive a fast car. I don't need loan. I don't need appraisal. I'm wheeling. I'm dealing. You're going to sell to me. No loan, no appraisal. Carr strongly discourages removing the investigation contingency, the informational access, whatever it means, the review of seller documents. They don't they don't favor removing those up front. And for good reason. I think the investigation of the property contingency is extremely important. I don't care what kind of buyer you've got. But they do tell you that any of these contingencies can be removed if you may be removed or waived by checking the applicable box above, so one of these, or attaching a contingency removal form with it. So if you want to remove, if you're a buyer and you want to really show that you're hot to trot, you can attach a CR to your offer. You check that box and you can remove any contingencies you want, all of them, one of them, whatever you want. But here's what Carr says: removal or waiver at the time of offer is against agent advice. See paragraph 8H. Well, we'll go take a look at paragraph 8H in a moment. But what that's saying is we're advising our buyers not to remove contingencies until they're confident that they're ready to remove that contingency. So the agreement has that language built in. It's also found in paragraph 8H. And we don't, generally speaking, want to contradict that. So if a buyer says, I want to remove loan and appraisal, you can say, well, look, that's an aggressive move. That's a good move. That'll probably get you noticed. But, you know, as a general rule, we don't advise that. It's up to you. If you're confident. Go ahead. I'm sorry, did someone have a question? Nobody? Got some background noise? Okay, my apologies. Okay, so keep in mind that advice. Confident, sophisticated, aggressive buyers are willing to do it, but for a first-time homeowner buyer or a standard residential family purchasing a home, I don't recommend removing any of these contingencies because, you know, you want to protect your buyer's earnest money deposit as much as you can. Let's just take a quick look at paragraph 8H just to see what it says. Yeah, it says here, removal of waive, buyer shall have no obligation to remove a contingency unless the seller has provided blah, blah, blah. That's an interesting provision. If buyer removes or waives any contingencies without an adequate understanding of the property's condition or buyer's ability to purchase, buyers acting against the advice of agent. Okay, so that's the standard advisory, but let's take a look at this. This is very interesting. I actually just noticed this, and you'll see that Carr put this in bold. So what Carr is saying is that buyer shall have no obligation to remove a contractual contingency unless seller has provided all required documents, reports, disclosures, and information pertaining to that contingency. Wow, that's kind of a big provision. And in the past, the seller could try to get the buyer to remove a contingency even if the seller hadn't provided all the documents. And I used to get phone calls all the time saying, we don't have to remove our contingency because the seller hasn't given us X, Y, Z. But Carr has now added in this phrase in bold and says, you don't have to remove a contingency unless the seller has provided all required documents, reports, and disclosures. In my opinion, that's kind of a big provision. And I'm not sure if that's going to help or hurt. I can see a lot of buyers out there saying, well, we don't have to remove a contingency because you haven't given me X, Y, Z. And I could see a seller saying, we've given you all that we've got. We don't have X, Y, Z. And you sort of got a dispute. It is what it is. I trust Carr. I do think that they have clarified this situation. And it's probably true that this is consistent with other parts of the previous agreement that used to say things like, if you get something, you have additional time to remove a contingency, et cetera. But they took it upon themselves to add this phrase in, which to my knowledge has never appeared before, or if it is, for whatever reason, I'm noticing it for the first time now. So I think that's a significant provision. I would encourage everybody to be aware of that. Okay, back up to the terms grid. Okay. So 17 days for all the material contingencies and general rule, don't remove a contingency unless the buyer is confident that they want to proceed. Don't rely on the loan and appraisal as being interconnected. They're not. And in fact, I'll tell you something else. Carr added another provision in this agreement, which makes it really important to have both of these contingencies. I think there's been a practice in the last year of trying to be aggressive with presenting offers by going in with only a loan contingency and not having an appraisal contingency. And one of the expressed rationales for this has been, well, if it underappraises, we won't get the loan, and then we'll just exercise the loan contingency. And prior to this agreement, generally speaking, I might not have had a real problem with that. It's clearly not consistent with the letter and the spirit of the appraisal and loan contingency, but it was a kind of a loophole. Not anymore, because now Carr has closed that loophole. This agreement, unless otherwise specified, blah, 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 is contingent upon buyer obtaining the loan specified. Buyer shall act diligently to get the loan. If there is no appraisal contingency or the appraisal contingency has been waived or removed, then the failure of the property to appraise at the purchase price does not entitle the buyer to exercise the cancellation right pursuant to the loan contingency. If buyer is otherwise qualified for the loan and buyer is able to satisfy lender's non-appraisal conditions for closing. So for me, being a nerd lawyer looking at this stuff, I kind of go, wow, that's kind of an interesting provision for me. I believe that's a brand new provision. And that takes away, or at least minimizes, a buyer's ability to sort of shed their appraisal contingency at the outset and try to say things like, hey, look at us, we're really super duper serious. We're not even going to have an appraisal contingency. And then whisper to the buyer, it's okay. If we underappraise, we'll just call it a loan contingency. Carr is now saying you're not supposed to do that. And so all the more reason not to sacrifice your appraisal contingency unless you're really sure, the buyer's really sure that's not a problem. Now, what does this language mean? If the buyer is otherwise qualified for the loan and buyer is able to satisfy lender's non-appraisal conditions for closing, well, I think I have a sense of what that means. But the point is, it's going to be harder to argue a loan contingency if the only thing you're basing it on is under appraisal after you waived or got rid of your appraisal contingency. So my advice is, Carr seems to have been tuned into this fact. I've been aware of it for over a year. Buyers taking out their appraisal contingencies to try to look better. Don't do that anymore. That's my advice. Keep it in there. If you want to remove it later, you can remove it, but don't remove it up front if you can help it. All right. So they have a paragraph here for possession. And I always like the term possession because as a lawyer, one of our most popular phrases is possession is 9/10 of ownership, meaning the person who's living in the property has 9/10 of what all the rights of ownership are because you got to move them out of there. That is an irrelevant aside, but I share it with you nonetheless. So the general rule here is that the time of possession for the buyer shall be upon notice of recordation, unless you check something else. So the default provision is when there's notice that the transfer deed has been recorded. If the seller, if the property is seller occupied or vacant, then the time of possession shall be the close of escrow, unless you check another box. And you have two options. One is the buyer will get possession 29 or fewer days after the close of escrow, or 30 or more days after the close of escrow. And you can pick either box. And then it says, if you're planning on having the seller stay there for 29 days or less, use Carr form SIP. Otherwise, use Carr form RLAS for more than 30 days. And, the point is, if a seller is going to carry over and it's going to be something 29 days or less, what you want to use is a seller in possession addendum, which is a relatively short form. It's about 1 or 2 pages, and it basically just says seller gets to stay there a little bit longer. But if they're staying there for 30 days or more, you're basically creating a tenancy. And the RLAS is basically a lease agreement, residential lease after sale. And the reason for this is that the law tends to view tenancies as being, 30 days or more usually has significance from a legal perspective as to whether or not there's a tenancy. And 30 days in the eyes of the law typically means a month, and it typically implies a month-to-month tenancy. So there's a specific provision in here to address this issue. And if you're a seller and you're going to need this provision, make sure to deal with it in an encounter. And if you're a buyer and you know the seller wants to linger and you want to try to make your offer more appealing, I've seen situations where I said to agents, look, the seller is the seller's looking at multiple offers. The seller's been there forever. Why don't you throw them a bone, give them an SIP for 29 days? And here's the real kicker, charge them $0. And people say, what do you mean $0? And I say, look, you don't care about the rent. You want your offer to be accepted. And if it's 29 days or less, now the seller has more incentive to take your offer. It's just a thought. I defer to all of you, but I typically don't like to see people charging money for these kinds of things. But each seller and buyer is different. I've seen sellers and buyers get so bogged down on canceling daily rent and interest and the cost of the mortgage. To me, it's just kind of a waste of time because the thing I'm focused on is it going to buy? Is it going to sell? Is it going to close? Isn't it going to close? But it's there, keep it in mind. And now for tenant occupied units. So if this is property with tenants, and there's an expectation that tenants are still going to be there upon the close, then this is the opportunity for the buyer or seller to say, guess what? This is tenant occupied. We're checking this box, and we're going to give you this attached CAR form called a TOPA. Now, I was looking at the TOPA, Tenant Occupied Property Addendum, and it seems to me it's a brand new form, TOPA, and it really has some great provisions in there. It has provisions in there that say things like, this is tenant occupied, and the buyer is going to buy it with the tenants, and the buyer inherits all the obligations of the landlord. And then there's another box where the seller can check, or it can be checked, and it says, if for any reason the seller, after a good faith effort to get the tenants out, can't get the tenants out, then the buyer has the right to cancel and get their deposit back. So I think it's a really great form, and it's worth everyone taking a look at it, because I get a lot of phone calls all the time about, well, the seller's supposed to deliver vacant and the tenant's not leaving. And everybody seems to act like that's a crisis. And I can understand why. To me, that's just a price issue. That's just a price issue. And I know people will tell me, oh, my buyers are adamant they're not buying with a tenant. And I say, well, what if the price dropped? Would they buy it then? And there's a price for everything. So I believe that this situation is common, and some buyers may be best served by buying property with tenants if they can get an appropriate price reduction. This form, TOPA, is a good form to use up front if you've got tenant occupied property. And if for any reason you learn during the escrow that the tenant's not going to get out, this TOPA could also be a good form of disclosure, saying to a buyer, look, the tenant's not leaving. We're submitting you this form. We're telling you that, and we're also telling you, I have the right to cancel and get your money back if that's what you want. But my seller is willing to talk about a price reduction if that's something you're interested in. I encourage you all to take a look at that form. It's a 1 or 2 page form. It's a brand new form. To my knowledge, it didn't exist until this agreement created it, but that's what they've got for tenant occupied properties. One other thing here, they have a 7-day deadline to install smoke alarms and carbon monoxide detectors, et cetera. I don't, my sense is that even though these are government requirements, I've never really seen an escrow fail to close because of them. I know it could happen, but I just wanted you to be aware, the contract says that whoever's responsible for putting in these things is supposed to do it in 7 days. So this is an example of something that someone could issue a notice to perform for. You could issue a notice to a seller or a buyer to do that, to install this, etc. It's not a contingency, it's called a notice to perform a contractual obligation. And then if they don't perform, there's a right to cancel. I merely point this out because it seems to me that putting it here sort of makes it more apparent, and it's something worth thinking about. But beyond that, I'm just calling it to your attention. And there's paragraph O, intentionally left blank.
Peter, I think it was put in there because people were getting having to have appraisers come back, and when the appropriate standardized, smoke alarms and CO detectors were not installed at the time of inspection.
Yeah. Okay. So it is an important need. 7 days is pretty quick, it seems for me. You could extend that. But the real thing that I think is significant, and again, here's paragraph 3O, aka 30, intentionally left blank, is the next page talks about who pays. And this is the last page of the grid. It's 3 pages long. This is section 3Q. And other than a few exceptions, all of these require the parties to specify who's paying, the buyer, the seller, or both. If they're not checked, then it seems to me no one has taken on that obligation. Now, there's some exceptions here. There's sort of a default provision that says the buyer pays for the buyer's lender's title insurance. That's great. HOA fee for preparing disclosures, the seller pays that. HOA certification fee, the buyer pays that. These could still be changed, but Carr has put in defaults there that basically say there's no reason not to have these people pay these fees, which makes sense. But every other thing, the natural hazard zone disclosure, smoke alarms, government required, escrow fees, owner's title, county transfer, this is all subject to buyer, seller, or both. So be mindful of that. You want to go through and check the appropriate boxes. If you don't like, as a seller, the box that was checked, you can counter it back. But unless these boxes are checked, no one has this obligation. Now, I'm going to finish my discussion of the paragraph 3 matrix grid, our tour through the matrix, if you will, is with this paragraph R. And let me just scroll up here a little bit. I'm going to magnify that a little bit for dramatic effect. Other terms. There's 3 lines here. And Carr agreements always have other terms provisions in them. And these other terms provisions are great. And I tend to find they're extremely short. And I think that's with good reason. If the buyers and the sellers or the agents want to add other terms, Carr is basically, in my opinion, saying, look, we've thought of just about everything. What possible other terms could you want to add? And it's a reminder that if you're trying to add terms that are going to go beyond these 3 lines, to me, it's a sign that maybe you want to stop and think about it, maybe call me, and we will most likely find that whatever other terms you're contemplating, they're probably already in here in some other place. So I like to talk about the other terms portion because I view it as Carr saying, look, don't overdo it with the other terms. If they're not going to fit in this space, it's a hint that maybe it's too much, maybe it's overkill. Now, never say never. There may be some situations, but I do believe that for the most part, this agreement is very well thought out, very self-contained, and it doesn't help us or the buyer or the seller to try to add extensive terms. And if you need help dealing with that, by all means, call me up and we'll talk about it. And we'll find the provisions that are in there probably already. Now, that's my whirlwind tour through the paragraph 3-page matrix. I want to pause for a minute here, ask if anybody has any other questions. There are some other provisions in the purchase agreement that I think have been tweaked or modified or are still in there. And we could spend roughly the last half hour or so dancing across those and touching upon some of those. But we covered a lot. And I want to give everybody a chance to take a breath and see if they have any questions they want to ask. And if nobody has anything, I'll just truck on through to the end.
Peter, I have something.
Yes, sir.
You keep saying this part's what I get calls about. Can you tell us which parts any other ones on the contract that you get calls about a lot?
Well, let's see. I frequently get calls about all cash buyers who are suddenly obtaining loans. And I tell them, you shouldn't be upset about that. They're allowed to do it. Are they going to close on time? Are they going to close for the purchase price? And they say to me, well, but I told my seller to take this because it was all cash. And I say, well, for future reference, don't oversell an all cash offer because, you know, it may not be an all cash offer. They may get a loan. So don't get too bogged down in that. I get a lot of calls about buyer-seller disputes, and you know, buyer-seller are fighting over this, they're fighting over that. Seller agreed to do this, the seller didn't do that, and that takes us down to sort of the mediation provision. And I'll briefly go to mediation because it's in there. And I think agents often feel frequently that it's their job to solve whatever dispute arises between buyers and sellers. And I can tell you that that's generally a good idea, but at the end of the day, it's ultimately not your responsibility. So what I get a lot is post-close disputes. And here's what Carr did with some of these provisions. So first of all, we have the liquidated damages provision, which is always in the contract, but Carr has sort of made it a point to put it in a big box like this so that it's very clear that this is kind of a separate provision. This provision doesn't exist unless both the buyer and the seller initial it. So they just sort of separated it. It doesn't seem to me that they changed it materially at all. The next paragraph is mediation. And this is what I was referring to. And you'll see mediation is built into the agreement. It doesn't have to be initialed. It says this mediation provision applies whether or not the arbitration provision is initialed. That's down here. So the buyer and the seller have agreed to mediate any disputes between them. And this typically happens, you know, post-close, something went wrong, there's a repair or something. And the agents try like heck to fix it. But at the end of the day, the buyer and the seller have agreed that if they have a problem, before they do anything else, they'll go to mediation. And there's a link, consumermediation.org. And the buyer or seller can click on that link and they can start mediation. They have to input some stuff. They have to pay a non-refundable fee. Most of them will be deterred the minute Carr says to them, you got to pay us $400. Most of them will say, well, I'm not doing that. This dispute is not worth it to me. They'll say, you do it for me. And I recommend you say, no, you have to do it. You're the party to the contract. I'll appear at mediation. I'll help you, but you have to initiate the process. So encourage people to use their mediation provisions. Arbitration. Occasionally I'll get phone calls about arbitration and people will say, oh, my guy or gal doesn't want to initial this provision. And Carr did the same thing. They sort of separated it off here and they boxed it in to make it clear that unless these things are initialed, arbitration is not part of it. My attitude is, look, they don't want to agree to arbitration. They don't have to. Most lawyers will tell you they would prefer to go to court rather than go to an arbitrator because they're just more accustomed to it. But generally speaking, people call me up and say, well, my guy doesn't want to sign arbitration. What do I do? And I say, I don't think it really matters. If they want to sign, they do. If they don't, they don't. We can talk about more details, but I don't think that's really important to get hung up on. Let's see. I don't get so many calls, but people are constantly providing me with documentation, and they love to put the phrase in as is, as is, as is. They think that somehow that's giving them some sort of extra protection. And I'll tell you again, it's already in the agreement. The agreement already says that the purchase is as is, so you don't need to add it to the agreement. All that as is means is that the seller is going to keep the property in its current physical condition, and the seller's not obligated to make any repairs. People think it means that if there's some sort of hidden, concealed defect there, you're covered by writing in as is. And the more you write as is on stuff, the more it triggers in my mind, well, what are they hiding? It's not necessary. It's in the contract. And unless the seller agrees to do repairs, they don't have to make repairs, and there's no reason to add the phrase as is. And this phrase has been in the car contracts for a long, long time, so there's no reason to add it. I get a lot of phone calls and emails regarding, releasing deposits non-refundable. And I'll tell you something here that most people aren't really aware of. The car agreements basically say that under a normal purchase agreement, if the buyer removes all their contingencies and doesn't close after the seller sends a demand to close, those three things have to happen. The buyer removes all their contingencies and then doesn't close, and then the seller sends a demand to close and the buyer still doesn't close. If those three things happen, in my opinion, that constitutes a buyer default, and then the buyer under the contract is entitled to the 3%. And CAR is trying really hard to make it so that the seller only gets the deposit if those three things happen. But what I see happen a lot is people agree to release deposits before the close of escrow. And I say to them, well, the contract doesn't really like that. And everybody says, oh, everybody wants to do it, we're going to do it. I say, fine, go ahead and do it. But CAR wants to discourage that, and they put in this provision, paragraph 29 is liquidated damages. Buyer and seller are advised to consult with a qualified California real estate attorney before adding any other clause specifying a remedy, such as a release or forfeiture of deposit, or making a deposit non-refundable for failure of buyer to complete the purchase. Any such clause shall be deemed invalid unless the clause independently satisfies the statutory liquidated damages requirements set forth in the Civil Code. What are the statutory requirements in the Civil Code? If you have to ask that question, you do not want to know the answer. You don't want to be there. And CAR is trying to discourage people from doing this, big for obvious reasons. I've seen situations where deposits get released and then suddenly the sale falls apart and the buyer wants his deposit back and the seller doesn't want to give it, and there's a fight. Alternatively, I've seen situations where large deposits get released and the buyer actually used that as like a bait and a fish hook, because now the seller has taken some amount of money, 50 or 100,000. Some sellers start spending it. They can't give it back. And the buyer says, I got you now. I got you now. You took the bait. So they can just reel you around and say, well, you don't get to keep my money and not sell me this property. And now I found all these other things. So I've seen it work both ways. I know people like to do it. And I just want you to be aware of this. I do get a lot of stuff on this. Same thing with per diems. I do not like per diems. I strongly discourage people from doing them. All a per diem is trying to pay more than the 3% liquidated damages deposit, or to make some portion of a deposit non-refundable. And for what? $100 a day, $200 a day? Where's that money coming from? Is it coming out of the buyer's deposit? Is the buyer putting more money in? I personally cannot stand per diems. I would strongly encourage people not to do them. And to me, they're just ways around these liquidated damages provisions. Buy the property or don't buy the property. Remove your contingencies and risk your deposit or don't remove them. Cancel or don't cancel, but don't transfer escrow monies or put on other penalties on top of these things beyond what the contract says. Please, this is just a constant repetition of the same theme over and over. Let the contract do the job. Don't try and reinvent it. Okay. I'll just briefly touch on brokers' duties. This is another paragraph. I talk a little bit about this paragraph almost every day because agents are constantly trying to do things that they're not supposed to do. So paragraph 18B, scope of duty, sounds like a video game, Call of Duty. These are all the things that you're not supposed to be doing as an agent. Buyer and the seller acknowledge and agree that agent does not decide the price, does not guarantee the condition of the property, does not guarantee the performance of inspections, does not have an obligation to inspect common areas, shall not be responsible for inspecting public records or permits, shall not be responsible for identifying boundary lines, shall not be responsible for determining fair market value of any personal property, shall not provide legal or tax advice or other information that exceeds our expertise. These are constant things that agents have a lot of pressure and they want to do all these things. And frequently they call me up and they say, we need legal advice. We need you to advise our buyer and seller. So give me the legal advice so I can give to them. And I have to say, well, we're not supposed to do that. And the buyer and the seller have agreed that they're going to do that. They're going to talk to their own professionals. And here's the problem. If I will certainly answer the legal question and I will inform you to the best of my ability as to what I think the outcome is. And then you're now informed and empowered to talk to your client in an intelligent way. But I would encourage you to avoid saying things like, well, my lawyer says this. And then your buyer or seller comes back and they always say, well, ask your lawyer this and ask your lawyer that. And boom, now they've created this sort of free legal services clinic hotline through you to me, and it doesn't work. I have to shut it down. And it also, if you don't say my lawyer says that, then you're the one giving the legal advice and you shouldn't be giving legal advice. So generally speaking, we should refrain from giving legal advice, and we should be mindful that we're not supposed to do some of the things that we constantly do. And I know that there's pressure on you guys to close sales. I know there's pressure on you guys to make your clients happy, to give them whatever they want. But I have learned in life that sometimes the best thing and the most powerful thing that you can do for some of your clients, and they will respect you more for it, is to occasionally tell them no. People really do respect that they can't push you beyond the brink. Now, I'm not telling you to do it all the time, and you have to pick and choose your battles, but they agreed that they're not going to ask you to do certain things. So I do recommend scope of duty, call of duty, same thing, that you guys take a little bit of time and review the thou shalt not list of non-commandments that you're supposed to, that they've agreed that you're supposed to comply with. It comes up constantly, day in and day out. You can deviate from these things, but just be mindful that you're stepping out of your lane, so to speak, and cover yourself. Well, I'm not a lawyer, I'm not a surveyor, I'm not a permit expert, but this person says this, these documents are this, but you have to double check it. I'm not an expert on these things. And I know that sometimes that's anathema for an agent to say, I'm not an expert on this, but believe me, it's an appropriate thing to say sometimes. And I think that your buyers or sellers will appreciate it when you say to them things like, look, I'm not an expert on this. Here's what I understand. Oh, this is a good one. Let's talk briefly about this. Supplemental TDS. Okay. A transfer disclosure statement is required for every sale of residential real property, 1 to 4 units. And it's required by statute, which means it cannot be waived. Any attempt by the parties to waive it, if either party comes back and says, well, I know I waived it, but I don't want to waive it, they're allowed to do that. The statute on its face says any attempt to waive this is invalid. Now, that doesn't mean that there may not be situations where the seller refuses to provide a TDS, but if a TDS is required, the very act of not providing it gives the buyer the right to cancel. It gives the buyer the right to cancel and ask for their money back. They may or may not choose to do that, but they have that right. If the buyer subsequently discovers something after the close of escrow and they didn't get a TDS, they have the right to sue because it wasn't disclosed. Okay, so TDS, very important. Generally speaking, we want to ask our sellers to provide it. But what happens if you provide a TDS or the disclosures and then you discover something else? Something else is discovered after these disclosures are provided. The old agreement said you're supposed to provide a supplemental TDS or some other written notice that discloses this new fact. And I get these calls all the time. We've discovered something new. It's horrific. It's the end of days. It's terrible. I'm so mortified. And I say, well, I don't care what it is. Just disclose it. But they're going to freak out. I say, who cares? Disclose it. Throw the snake into the room. Let's see what the reaction is. Be brave. Disclose it. Disclose it. So the contract says you're supposed to use a supplemental or amended TDS for that, or a supplemental or amended SPQ. But it also says you can use any other document in writing covering the items that need to be disclosed. So, you know, I recommend a TDS or an SPQ, a supplemental, or even an addendum that says, you know, seller hereby discloses whatever, blah, blah, blah. But if worst case comes to worst case, an email from the agent to the other agent, from the listing agent to the buyer's agent, will be sufficient. For example, let's say your seller refuses to sign something. You can make the disclosure. And here's the interesting part. The old document, the old agreement said that if you disclosed that, the buyer gets an additional 3 days or something to cancel. This says that any such written disclosure like that shall be deemed an amendment to the TDS or the SPQ. So even if it's not on a TDS form, this says it's going to be deemed an amendment to the TDS or the SPQ, which means it automatically gives the buyer a cancellation right. Now, the TDS has a 3-day cancellation right. If you look at the bottom of the TDS, it has a 3-day cancellation right. So any kind of disclosure like this, I would argue, gives the buyer 3 days after receipt to cancel, even if they've removed all their contingencies. But it has to be something that the buyer didn't already know before. Now, there can be debates over that. There can be issues over that. But if you're in a situation where your buyer has removed all their contingencies and some new fact has come up, I might encourage the listing agent, if the listing agent calls you and tells you and says, listen, this just happened, I'm telling you now, I would encourage the listing agent to send you something in writing to that effect and say, listen, I really appreciate it. Thank you for disclosing this to me. I don't think it's going to be a big deal with my buyers. Maybe it will be, maybe it won't be. But you want the listing agent to send you something in writing saying, here, we're disclosing this. Nice talking with you on the phone about it. Here it is. Hope your buyers are still willing to move forward. You get that. And now you can argue that your buyer has 3 days from the receipt of that to try to cancel and get their deposit back. Maybe they will, maybe they won't. But this is the language that I thought was interesting. Any such written notice shall be deemed an amendment to the TDS or SPQ, and those are material disclosures. So they tweaked that form a little bit. They used to expressly say that you had 3 extra days. Now they're saying it's slightly different. It's an amendment to the TDS or SPQ, but either way, I believe it gives the buyer 3 extra days to cancel and request their deposit back. All right. It's 2:50. I've gone on and on and on. I apologize. If anybody has any other questions or something, I'm happy to try to address them. And if I've sucked the air out of the room, I understand that. Oh boy, that was quite a sigh. Oh my God, this guy won't stop talking. Let's see. I think I talked about deposit remedies, other terms. Well, I think I've pretty much gone through all the high points that I can see, but we're all going to learn this agreement together. There are probably things in here that I haven't addressed, and we're going to discover that together as we go through. You're going to say, hey, look at this. Hey, what about this? And we're going to talk about it. And we're going to teach each other. I remind everybody to be aware of where are the definitions? Let's see, definitions. Many of the answers to questions are contained in the definitions. And so I encourage people to be aware of where the definitions are. Where are the definitions? Yeah, there they are. So definitions are found at paragraph 25. And I would encourage you, if you have questions about certain things, oftentimes the answers will be in the definitions section. What is acceptance? What's an agent? What's an agreement? What does as is mean? That seems new. I'm not sure they ever defined it before. Close of escrow, counting days. They give you a primer on how to count days. What's a day? What does a day mean? What does law mean? Electronic copy, electronic signature. So some of these look new. They've added stuff, but the definitions are important. They put them in there for a reason. And lots of your questions can be found just by looking at the definitions. And if you still have questions, then obviously we'll talk about them.
Hey, Peter, it's Star Jasper. How are you?
Hello, Star. How are you?
I'm good. I was just wondering if we could just go over 3D1 one more time.
Sure. Okay.
Okay, I don't know, it's very tiny now. I don't know.
Oh, let me,
Oh, there we go.
can
Okay.
everybody see it? I magnified it.
It's just the initial deposit amount. I know you want us to write the percentage, and then just under that, it says the percentage number above is for calculation purposes only and not a contractual term. So is Carr saying that they would prefer, if one or the other, to put the monetary amount, but we
Well-
can't leave that out?
Well, I do think that an offer needs to have a deposit amount specified. A, because it should be specified. The other provisions of the contract require it. And B, I don't think any seller is going to respond well to a contract that basically leaves that blank, which implies we're not putting down any deposit. So you have to specify it. My opinion is that putting down the percentage is better, because even though it says that 3% is for calculation purposes and is not a contractual term, I'm not quite sure why Carr is saying that, because I do believe it is a contractual term. You're putting down 3% of the purchase price. But I think that what they're doing is they're trying to deal with any confusion. So I think, as I'm sitting here thinking it through, I think that if you write down 30,000 on a 1 million purchase and you put 3%, I think what they're saying is that later on, if the price changes, the 30,000 wins. That's what I think they're doing that. Now, is that the best way to do it? Maybe, maybe not. I defer to you. If you really wanted to be safe and write 30,000 and 3%, you could. And then if it turns into a $1.1 million purchase, you could then say, well, we only agreed to put down 30,000, And yeah, we said 3%, but that's not a contractual term. So it's 30,000. So I think that's the intent by what Carr did there. So with my interpretation on the spot, that's how I would read that.
Okay, thank you.
Peter,
Yes.
in relation to that, I've had situations with escrow where we've started with whatever that number was, and then there was an increase, but they never changed it in all the escrow instructions. So if they just left it alone, in other words, they didn't tweak purchase prices and things like that. And I know in the past I was very confused about that, you know, and then they would be like, well, no, we just went off the initial, the original purchase agreement, not the counter offers. Can you address that at all? Have you seen that
Well,
occur?
I'm not really sure what you described right there, but bottom line is this. I don't think a buyer should put in more than 3%. And if they put in a little bit less than 3%, frankly, what's the big deal? You know, it's a significant amount of money any way you look at it. And they're putting it into deposit. And I know that the deposits can be somewhat important or people can be mindful of them. But as long as it's 3%, or somewhere very close to that, I just don't think it matters. Now, if the original contract, for whatever reason, said 3% of the purchase price, but then there was a counter and the purchase price went to 1.1, so the deposit should have been 33,000, but escrow just saw 3%, or they just saw 30,000 and they never changed it, and they just said 30,000 throughout. My attitude would be, well, let's roll with it. 30,000 it is. And I wouldn't get too bogged down in whether it's 30,000 or 33, whatever, you know. I just don't think it's that big a deal as long as the buyer, in my opinion, is not putting in more than 3%.
Yeah, I agree with you, Peter. I would say if
Sorry.
Lena, 1 second. If it's important to the seller and the seller's agent for that adjustment to take place, then they should be putting that in a counter offer to consider that, right? Purchase price to be, even if it was best and final, purchase price to be, buyer's deposit to be adjusted with the terms of the purchase price, right? I mean, if it's that important to them, then they should proactively adjust it via the agreement, right?
Yeah, I agree. And most sellers, frankly, they're not even looking at that. They're staring at the purchase price and they're counting their chickens. That's what's going on. So, you know, if you're representing the buyer, just, you know, I would make sure that your deposit is 3% or less, and a little bit less to me is not a big deal. And if it is, the seller will let you know and you guys will deal with it.
Okay, great. Yeah, I mean, I didn't have an issue. I just brought it up because earlier on I had trouble getting the math to work when I was going through all the forms, and then basically, you know, escrow made it work at the end, you know, so I just wanted to kind of bring it up, but I don't think with it.
Yeah, let's all take a moment. I recommend that everybody take a moment and just think to yourself, thank goodness for escrow. I mean, these people, in my experience, are sort of the unsung heroes of transactions. They do a ton of work. They're duplicating everything. They're trying to help us every chance they can. And, you know, after thousands of conversations with escrow officers, I'm always amazed at how hard they work and how much they have to do. And they usually try to make it work out in the end. And if there's a mistake, they usually try to catch it. And God bless escrow. That's my personal opinion. And you should all consider taking a moment to thank your favorite escrow officer for all they do for you. But in my opinion, that's the kind of stuff they do. They will make it work out in the end. That's just my soapbox 2 cents on, what is today, Tuesday? Crickets.
Agreed.
Okay, real quickly. The liquidated damages clause says seller shall retain his liquidated damages the deposit actually paid. And if the property is no more than 1 to 4 units, the amount the seller gets shall be no more than 3%. So if you put in less than 3%, that's what the seller gets. If you put in more than 3%, the seller's only allowed the 3%. And my advice is don't put in more than 3%, no matter what you do, unless there's some good reason for it. Anything else? Somebody take away my microphone. Hello?
Thank you, Peter.
Oh, okay. Well, I hope this has been helpful. Thank you all very, very much. And we'll be talking to everybody soon.
Thank you. This was great.
Oh, I'm
Thank you
glad to
so
hear
much.
that. Thank you so much.
Have a great day.
Thank
Much
you.
appreciated.
It's your world. Everybody else just living in it. Go out there and get them. Take care.